Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're talking about red flag laws, or ERPOs, and we're joined by an expert on the topic. We have Jody Madeira, a professor of law at Indiana Bloomington Maurer School of Law. Jody, nice to talk to you today.
Thank you for having me on.
Why don't we start with what is a red flag law?
Well, we call them red flag laws. That's sort of what we see in the newspaper. But red flag laws, or extreme risk protection orders, or ERPOs, come under a variety of other names. They can be extreme substantial risk orders, like Virginia uses, or even risk warrants, like Connecticut uses. And they're civil, not criminal orders. They're actually modeled after domestic violence protection orders, but they really just address gun violence. And in general, you could say that ERPOs are tools in state law that actually can help prevent someone in crisis from harming themselves or harming others.
Is this a reaction to some of the mass shooting tragedies where we see usually a troubled young man shooting up a school or a mall, and then we wonder, what could we have done?
Actually, legislative initiatives to pass ERPOs, or red flag laws, often accompany these very unfortunate mass incidents. But rather, ERPOs are best to address more garden variety, although I hate to say it, everyday types of gun violence. They're really predicated on the understanding that gun violence is a preventable problem, and that there are actually measures we can take to help individuals in crisis and to protect public safety and protect Second Amendment rights all at the same time.
The justification there is let people have their Second Amendment right. It's just the people with dangerous mental or emotional troubles who we need to worry about.
Yes, absolutely. Individuals who are dangerous to themselves or others. And it's not just like a possibility. There has to be more of a demonstrated probability. Some say substantial likelihood. Some say, there has to be clear and convincing evidence in order to protect important due process considerations.
That's a good point. So these are state by state, and I'm picking up on the fact that there's some variety or spread amongst the states. Maybe you could talk through the process or the procedure for taking away someone's gun.
Well, I think there's a couple of different levels to talk about. First, there's the federal level, and second, I'll talk about the state level. So currently, there's no federal ERPO law, although the federal government did try to pass one in 2022. But our most recent comprehensive gun legislation on the federal level, the Bipartisan Safer Communities Act, and this act actually did allocate $750 million to states that support starting or maintaining crisis intervention programs for state courts. And this can include, mental health courts, veterans courts, or drug courts, as well as those that do pass red flag laws. And these are measures that attract widespread citizen support. 85% of voters support this legislation.
The federal law, while it doesn't create a red flag or ERPO, it creates funding for them?
It actually creates funding to help states support red flag efforts. Yes.
So at the national level, we have some additional funding for these ERPO laws. What's going on in the laboratories of legislation at the state level?
That's a great question. And so how ERPOs work differs widely from state to state. And so they differ in several key ways. First of all, they differ according to who can file a petition regarding an individual that's of concern because they're in crisis. They differ as to whether a warrant is required. They differ in terms of what a court considers in terms of evidence before ordering that firearms can be removed. And basically what evidence is needed to make a showing that firearms need to be removed. They differ in terms of how long firearm restrictions are in place, and they differ in terms of the due process, or how an individual that's subject to an ERPO petition can regain firearm access. So let's take who can petition first. So in some states like Indiana, law enforcement has to be the party to file the request or petition before the court in order to temporarily block someone in crisis from having access to firearms. But this doesn't mean that law enforcement has to be the party that notices this person at first. Of course, they can actually take inquiries from any concerned citizen, a teacher, a parent, a guardian, a coworker, a roommate.
So if I noticed that my brother was having some violent outbursts, was making kind of some threatening and dangerous statements, and I was seeing some mental health. And by the way, if he watches this, this is hypothetical. I could call the police and say, look, I'm concerned. Can you take necessary measures?
Yes. And basically, the police have to be the ones to officially start the process. But often these calls come in just from people in the community who are concerned about a loved one, about someone they know and care about, etc. And just because someone makes a red flag call or, an ERPO petition request of the police, it's basically a request for a deeper investigation. That does not mean that the police are going to act on it. That means that the police may look into it depending on that information.
So the next level of difference that you mentioned was the standard required, the amount of danger that was required?
Yep. And the amount of danger, well, it's really a question of probability. And probability means likelihood. Some states require more imminent behaviors or signs, direct threats, for example, on social media, direct statements to people. Others, basically, it's based on may. And it's, again, a judgment that this is likely to happen. And again, back to the question of who can report. We talked about, police in some states being the ones to make the filings. In other states, you might have people in the community who can go to the courts directly, teachers, employers, family members. And so that's the minority of states. But I think basically, whoever makes this petition tries to get that best evidence before the court, whether there are writings, whether there are statements, again, any recordings. So the court has the fullest record it can have to make this important decision going forward.
So you're skipping one level of filter, which I imagine in some regions where these laws are politically hot or contentious, and maybe law enforcement doesn't feel inclined to put their full weight behind it, that could give a direct path to the courts.
Yes, and we've had some areas, more rural areas in the United States, for example, where sheriffs in particular, demonstrate questions like, are these compliant with the Second Amendment? Do they infringe upon due process or Second Amendment rights? And I think actually, of course, the answer is no. We can talk about that later. But in that circumstance, there might be problems of enforcement. And so certainly in those states that do allow an expanded population to report directly to the courts, that might overcome some law enforcement resistance. And it's just, again, very important to emphasize that even when you have this expanded access to the courts directly, there might be other requirements that must be fulfilled for due process protections. And so, for example, let's take a look at California. California allows some additional groups to file, like employers, employees, teachers. Coworkers can only file if they've had substantial interaction with an individual in crisis for at least 1 year. And so that's a long period of time, ample time to review somebody's behavior probably, and they need the employer's permission to file. Teachers must have interacted with a student for several months, 6, and they must have school administration approval before filing. So again, I don't think that we're looking at the type of tool here that can be used willy-nilly or without careful consideration by individuals.
They're trying to avoid this, hey, let me create drama for my neighbor, or let me be hysterical over something that was perhaps minor.
Exactly. Yes. And there's several due process protections which we can get into. And this also, begs the question of how long these measures last.
Yeah, that's really interesting because I don't think you would want these to be permanent.
Right. Not unless the crisis or the mental health condition, for example, that warrants this is itself permanent and there's no steps being taken to alleviate it, for example, like medication. These measures are actually intended to be temporary. And even if the condition lasts, there's going to be frequent times where a court goes back and revisits just to make sure that the individual is safer without access to firearms and that those requirements are still fulfilled.
For it to become permanent, does it require some type of hearing where the individual has a right to participate or some type of finding of fact?
Yes. So let's talk a little bit about what a court can do. Some states allow so-called ex parte hearings, which in emergency situations, and it's a very high threshold to prove an emergency exists, they allow a court to issue an order without notice to the individual in crisis. But that, again, requires this immediate risk of danger to self or others. And so, again, these orders that are given without notice to the person who's subject to them are just in place for a very short period of time, 2 weeks at most, and then a hearing has to be held or the order expires. Someone subject to this ex parte hearing has very important due process rights. They get a hearing in court, of course, where they are present and they can produce evidence as to why they should not be subject to an ERPO petition or sort of, present their side, tell their story. And so in those proceedings, there's a lot of safeguards to make sure that ERPOs are not ordered in error. And again, courts can always say no to an ERPO petition and actually do say no. A petitioner also has to confirm under oath that certain facts are true. And so there's criminal consequences for those that would make up facts that, and again, if an individual says, I'm concerned, but, I don't really have any specific reason why I'm concerned, that's not information that's going to be successful in an ERPO petition.
You mentioned that these laws generally focus on guns. Are they specific? Is it all guns? Is it weapons? Are they going to take away, someone's crossbow if they're seen as a particular danger? How does that part work?
I believe it would be all weapons that could fire projectiles. I don't think I've heard of an ERPO petition being filed for knives, but I've certainly heard of, for example, let's hypothetically say an individual in crisis who's shooting a bow and arrow off the deck of his apartment on the second floor in an apartment complex. Let's say that.
Extremely
evidence
reckless.
is that they're in mental health crisis. And again, just to emphasize, a little bit more on these due process protections, not only do you have to have this very specific information, but it's also in many states a crime to file an ERPO petition using false information. And again, there's very harsh penalties up to and including imprisonment and fines.
That should give some comfort to those who are highly skeptical of these, that look, if you frivolously waste the court's time, if you, for no good reason, take away someone's, even temporarily, someone's Second Amendment protected property, then there are real consequences.
Exactly. And some states, again, have not even red flag laws or ERPOs, but they have what's called yellow flag laws. For example, Maine. And these states even want to add in another layer of due process protection, and they allow law enforcement, police, prosecutors to petition for permission to remove firearms, but they require that the individual in crisis first be assessed by a medical professional. And so that's even an additional threshold. Irrespective of who reports the concern, there's this intervention of a medical expert who can advise on the situation.
They don't have to sit down with the individual, because I imagine that would, or do they?
They do, actually. Must be evaluated by a mental health professional.
So there's additional due process. There's additional, diligence, but it might not be as quick or as nimble as some of the other laws.
Exactly. And many times you get that type of evidence in states that do allow these emergency ex parte orders as well. But that evidence comes in at the first hearing, for example, as to whether the order should be extended past a 2-week period.
Professor, is there data on these laws, or are they too new? I guess I'm curious what level of ERPO is effective, or what level of these red flag laws are helpful in reducing, tragic violence?
That's a great question. So we do know that there's data out there, but that's a valid question for many types of gun violence prevention laws that are just being passed recently. And so, for example, Connecticut has had their ERPO law since 1999, and Indiana has had theirs since 2005. So when you look at the social science research on ERPOs, those are the two states that you tend to find most often represented in the literature. And research looks at not only, criminal uses, of course, mass violence incidents, but also they look at suicides. And that's, of course, of key concern in these prevention orders as well. Research actually has a robust finding that ERPOs, or temporary firearm removals, do help to prevent suicide, do help to prevent individuals in crisis from actually committing acts that they will later regret and they will have lifelong consequences. And again, we do have a good data foundation for these findings of up to 20 years of data from a single state. It's interesting that the effectiveness of ERPOs has increased in the wake of basically highly publicized shootings like Virginia Tech, for example, early on. Because after these mass shooting events, law enforcement starts to educate themselves on how to enforce that law, and the public hears, whether or not there's a red flag law available. And so incidents of reporting often increase after mass shootings that are, of course, highly publicized. And it doesn't have to be in that same state. You could have, for example, Parkland in Florida, and that would also probably have an increase in the amount of ERPO petitions filed in Indiana in some ways. So while we think of ERPOs as a tool to prevent mass shootings, they actually appear to be much more effective in preventing the bulk of gun violence, which doesn't stem from these very highly publicized and scary mass shootings, but also from suicides and just interpersonal domestic gun violence, etc.
Which makes some sense because since mass shootings are more rare, the data on mass shootings, you're more of a data scientist than I am, but it'd be much more difficult to get statistical significance on that.
Exactly. Yes.
Professor, I'd like to pivot. There's a couple of cases in the Second Amendment field that were really landmark. One is quite recent, the Bruen case. That changed some things in the way we understand gun rights and the way we understand gun regulation. One was this focus on text, history, and tradition that was brought up under Bruen. How does that work? Because clearly, at the time of the founding, they weren't doing ERPOs or red flag laws.
Right. And there weren't even police departments or probably even mental health experts that were, credentialed as such. So when the U.S. Supreme Court decided Bruen in 2022, before then, it's important to emphasize that no court had actually overturned an ERPO law as being unconstitutional or in violation of due process. Courts simply found they didn't impermissibly infringe on Second Amendment rights. But under the test outlined in Bruen, courts are required again to apply a very different test. And as you said, this is whether ERPO laws would have this sort of historical analog that dates from, 1791 or 1868. The problem is that when you don't have police departments and when you don't have mental health standards and
hard.
you don't have public education mechanisms, how are you going to remove access to firearms for individuals?
You tell me, Professor.
I think at that time, individuals were much more likely to be looked after by family and friends. And so, they're the ones who removed firearms and concealed them. So again, Bruen has had some important effects on ERPO laws, including striking down one law in particular as unconstitutional.
What happened there? Was that one of the state laws?
Yes. So in a lower level court found after Bruen came down that New York's ERPO law was unconstitutional because it lacked additional protections that basically New York had in its laws permitting involuntary commitment. And so, for example, the mental health law permitted doctors to refer someone for commitment, and that's it, point blank. And it also required periodic reassessment by medical professionals. But in New York, an ERPO could be started by someone who wasn't a physician and wasn't subject to expert review. So the court basically said, well, someone who's subject to these violations, these infringements, should actually receive the same protections as someone who's, being committed involuntarily. I have my beef with this decision. I think it's not historically sound. In early America, individuals committed to insane asylums or institutions often did not receive any constitutional due process protections because it wasn't regarded as a loss of liberty sufficient to trigger constitutional concerns. And so the historical analogs there break down. And to make matters even more confusing, recently, another lower level court in the same state, in New York, came to the opposite conclusion. And they found that the ERPO law was constitutional because historical analogs authorized private force to prevent someone from taking their life, or, of course, committing suicide. So I think the jury is out right now. One thing that I think is really interesting is that, courts seem to be reviewing these on the same grounds as other Second Amendment types of regulations, but they're very different. ERPOs are challenges to due process, right? Have we given someone enough due process before taking away their access to firearms? But the laws regarding due process after state emergency deprivations don't trigger the Second Amendment. They're not within the scope of the Second Amendment. And so I think it's very credible that courts are simply applying the wrong analysis. Since they don't trigger Second Amendment protections, basically it's a due process analysis instead.
What do you mean by it doesn't trigger the Second Amendment?
So at an initial point, Bruin changes basically only apply to laws that implicate the Second Amendment right to keep and bear arms. But there's an argument by some legal experts that ERPO laws actually don't implicate Second Amendment rights. They implicate due process rights because they follow from state emergency deprivations. And so, in other words, it would be outside the scope of the Second Amendment.
Jody, is that kind of in the same vein that we don't expect prison inmates to have a Second Amendment right? So maybe we wouldn't expect someone who's emotionally fraught and extremely dangerous to have a Second Amendment right?
Exactly. And so, and the question is not whether they have Second Amendment rights per se. The question is really whether, are these individuals competent to exercise any rights? And so, the state emergency intervention, again, this due process standard might be the better test and not Second Amendment. Of course, I think for an individual who's not in crisis, it clearly implicates Second Amendment grounds. If you or I, for example, are not individuals in crisis and somebody walks up and wants to take our firearms, that's going to be a very different consideration that implicates the Second Amendment instead of, for example, there's a danger that I might take my life or take someone else's life. And that's, again, in that moment, a different inquiry.
So it sounds like there's some legal issues that are still up in the air after Bruin, or at least some certainty that additional lawsuits will be filed on these red flag or ERPO laws.
Yes. And I think, again, a lot is just up in the air because it's quite different and difficult to see the world post-Bruin because we just haven't had much of a word from the U.S. Supreme Court, for example, on what a historical analog is, how closely it has to map onto a law, and red flag laws aren't the only issue implicated by this difficulty. One can't evaluate how easy it is or how much of a Second Amendment violation it would be to prohibit individuals taking firearms on subways in New York, for example, because there weren't subways in 1791 or 1868. So again, how loose can the relationship be? And again, I think we're going to see courts coming to divergent conclusions on these questions. Another area, in fact, that is very relevant post-Bruin is the difference between civil deprivations of firearm rights and criminal deprivations of firearm rights. Going back to what you said, comparing ERPOs to prisoners who lose their rights of access. And so actually, in U.S. versus Rahimi, which deals with surrenders of firearms after being subject to civil protection orders in the domestic violence circumstance, Rahimi, we saw the Fifth Circuit and the lower courts, again, being very conservative, literally, about these things and saying, well, you really need a criminal inquiry when the deprivation is due to a threat of violence. And again, you need a conviction almost before that's warranted. And so again, I think that's one thing that we're going to keep our eye on. Are some civil forfeitures allowable under the Second Amendment or under due process protections, or does this have to go through some kind of criminal proceeding?
Professor, we've been talking about how they work. I guess another question is, do they work? What level of uptake are these laws getting?
Well, I think it depends on, how much public education efforts the state puts in when they pass the law, because ERPOs are only really effective to the extent that they're used. And of course, effective to the extent people feel comfortable filing a petition. And a state can pass an ERPO law, but unless people actually file petitions, courts also have to act on them, right? And interestingly, it's a pretty red gun-friendly state where we see the most ERPO petitions. In 2020, it was Florida. And this really drives home the point that ERPOs are not anti-Second Amendment. They're not a tool that should be shunned by states. They're a tool that's really there in moments of crisis to be used.
You mentioned that ERPOs or red flag laws are broadly popular in national polls. They're also I don't want to say hated, but they're feared, or there's a great deal of concern among certain segments. How would you explain that? Are they misinterpreting the laws, or is it a valid concern?
I think if you just hear a description of a red flag law or an ERPO petition, it does sound like something that the reasonable citizen should be concerned about, again, because the due process protections are not evident. But I think there's a lot of misunderstandings out there about ERPOs that actually could keep someone from filing a petition or alerting law enforcement that are easily countered. And so, for example, we tend to think of these as being adversarial proceedings, but individuals in crisis often agree to the order. For example, in Florida, where they're most implemented, Broward County, this happens about 90% of the time that individuals in crisis actually agree to the order. Another misconception is that ERPO petitions just are there to respond to mental health crises, right? But oftentimes, it's really just more than one issue. The individual might have a substance abuse problem. There's overlapping threats of violence, for example. And so they just happen to overlap with owning weapons. It's not the gun that's the focus of the inquiry, it's the individual in crisis. And there's also just a common misconception that courts will just rubber stamp these petitions, and that's not true. Courts are much more likely to grant petitions filed by law enforcement, and some courts grant over, slightly over half of petitions, and some grant the vast majority. But again, it depends whether law enforcement are filing.
It's super interesting. I wouldn't have expected that the majority of the cases that you mentioned in Florida, the individual agrees, and so maybe the police officer says,
right,
Dave, I'm going to have to take your gun away. You've been doing some crazy stuff, and he says, okay, yeah, I get it.
Yeah, exactly.
Jody Madeira is a professor of law at the Maurer School of Law at Indiana Bloomington. Jody, thank you so much for your time today.
Thank you.